Welcome to Prime Point. We are so excited that you have chosen to join us. This presentation is provided to educate you on the New Jersey Paid Sick Leave Law. If you have any questions, please feel free to contact your sales representative or myself, Judy Saylor, at Prime Point. If you have attended one of our presentations that Prime Point has provided, please note that this presentation is updated with the latest regulations. The New Jersey Sick Leave Law takes effect on October 29, 2018. The critical piece to note is that all employees, with few exclusions, working in the state of New Jersey are eligible to earn 1 hour of sick leave for every 30 hours worked. Current employees would be eligible to use the earned time starting February 26th, while new employees hired after October 29th can use the earned sick time 120 days after the date of hire. The accrual that must be followed is shown here. Anything over 30 hours is a remainder and starts the next bucket. This continues until the employee reaches 40 hours of accrued time. The law stipulates that employees can earn and use no more than 40 hours in any benefit year. The benefit year is a period of 12 consecutive months, during which an employee can accrue sick leave time. The regulations that were provided on September 18th further expand this to say that the employer shall establish a single benefit year for all employees. The law states that an employee means an individual engaged in service to an employer in the business of the employer for compensation. This then includes full-time, variable hour, and seasonal employees. Employees who are contracted through a temporary service firm will accrue time and receive that time from the temp agency, that vendor, not the individual employer. Who the law does exclude from earning paid sick leave are construction, those under a CBA, per diem hospital healthcare employees, and public employees already covered by law, rule, or regulation of the state. The law goes so far as to clarify what a per diem healthcare employee is. It is an individual performing work for a hospital system on an as-needed basis to replace or substitute for a temporarily absent hospital employee who works a flexible or non-flexible schedule, that is a licensed healthcare professional or an applicant to NJDCA who works on an as-needed basis when they say they can work to provide healthcare services and employed by a licensed facility or a first aid, rescue, or ambulance squad member employed by a hospital system. There are standards set for the employee transfers, terminations, or other changes to their employee, as well as if an organization is bought, sold, or acquired by another entity. Any earned sick leave time that is taken must be paid at the same rate of pay with the same benefits as the employee normally earns, except that pay rate shall not be less than minimum wage. An employee can use their earned sick time for any of the following reasons: personal illness, family illness, domestic violence, closing of the workplace, a child's school or childcare by the order of a public official, or in order to attend a school-related conference or meeting for a child. Please note to review the definition of family. As an employer, you can request advance notice on foreseeable absences, doctor's appointments, physicals, testing, etc. And of course, if an employee is absent 3 consecutive days, you can request a doctor's note. Documentation is either a doctor's note from the employee doctor or testing center, or documents on domestic violence, public order, etc. School districts can provide a note from the office if your presence is requested for your child. Now we start into the tricky areas. The definition of family is extensive, and the new regulations do not finalize what close association might be. In the regulations, it says, for the purpose of this definition, an individual whose close association with the employee is the equivalent of a family relationship shall include any person with whom the employee has a significant personal bond that is or is like a family relationship, regardless of biological or legal relationship. This does not close that loop, but one would think if someone had a significant personal bond, coworkers and managers would have heard about the individual and that relationship. When an employee uses their time, the employer cannot make them find subs for their shift. It is the responsibility of the organization to do that. One question you have to answer now is, do you carry over or pay out the earned time? If you carry over, employees can only carry over up to 40 hours in a benefit year. As an employer, you can set certain industry dates aside that are blacked out so that employees cannot take earned sick leave for foreseeable absences. In retail, that might be the day after Thanksgiving. In a municipality, it might be National Night Out or the July 4th parade, events where it is all hands on deck to accomplish the task. One of the questions your organization needs to answer is, will you pay out or carry over time? You do not need to buy unused sick time. The law says you do not have to buy unused time back. If you choose to do a payout, then you need to decide if you will front load or accrue the time. For both options, you must ask the employee in the final month of the benefit year what they would like to do. For accrued time, they can either receive a full payout of unused time or 50% and the ability to carry over time into the next benefit year. For the full complement, you must do a full payout or provide them the ability to carry all of their unused sick time into the next benefit year. PTO, yes, it can count and be in compliance with the New Jersey sick leave law if everyone is covered by it. It is 40 hours or more, accrues at the same rate or better, is allowed to be used for the purposes listed in the law, is paid out to the employee at their rate or no less than minimum wage, is either paid out or carried over, and does not have the same restrictions as scheduled vacations or scheduled personal days do. So if your PTO meets those items, have it reviewed by counsel and then leave it as is. If it does not, can you establish a separate leave bank for the sick leave provided by the law? Check with your legal counsel. If not, bring your existing policy into compliance. With record keeping, the best guidance we have heard from legal counsel has been to have the time tracked on an employee's paycheck or in a time and attendance portal so that when and if you have to produce documents, you have it readily available. These records have to be kept for 5 years, but legal counsel is suggesting 6, current year plus 5, due to the Diane B. Allen Equal Pay Act. Train your supervisors that the reason folks ask for the New Jersey sick leave time is to be kept confidential. The state has committed to providing a model letter and signage to support the law. The letter will have to be given to or electronically provided to all staff and will require sign-off to acknowledge receipt. In terms of municipalities, the law states that there can be no override by act, ordinance, resolution, rule, or regulation. This is to be the final standard. For companies that are under a CBA, according to legal counsel, the CBA stands until it expires, and once expired, must meet the New Jersey sick leave standard. The law is clear that retaliation from a staff person or an organization will not be tolerated. You cannot terminate or discipline an employee for using sick leave pay with or without notice. In addition, there is a 90-day window of specified protection for occurrences like the protection of an employee for filing a complaint, the employee informs others of the alleged violations, the employee is cooperating in an investigation, the employee opposes any unlawful act under the law, or the employee informs others of their rights under the law. There are fines associated with retaliation. The penalties for non-compliance, not retaliation, are as listed. Much like the ACA, there is an expectation to do this with the deadline provided. We have put together a checklist of the items from the law that you should review for compliance. This does not guarantee you are compliant, but it can help you in your quest to achieve it. You should contact legal counsel if you have any concerns. We want to provide some guidance relating to best practices. As you can see, your leadership is a key part to being compliant. It is time to be strategic and bring all decision makers together. They need to be aware and prepared to respond accordingly to requests from staff. Now it's the time to review your CBAs. You know what the compliance is, prepare everyone for it, and have the policy ready for negotiations. Review your handbook. If you have to, seek out a professional to review it for you. Look at the key issues of the law for compliance. We no longer can do use it or lose it as an option. Go over the definition of family. It is very broad. Be sure you have covered all your bases. To remind you, a model letter will come from the state. That letter must be in your employee's hands within 30 days of receipt of that letter. At Prime Point, we have solutions that fit all sizes of businesses. We offer a time and labor system, a dynamic accrual, or a static accrual. You have the ability to make the best choice for your business. I want to thank you for taking the time to review our presentation. Please note that if you have any concerns, you should contact your legal counsel. If you have any questions for me, my email address is provided. Thanks and have a great day.